Hello. We're back. Last time we went over Ben Susan Restaurant versus King, and that was the Blue Note case, right? That was the name of the restaurant in which they filed a copyright suit over the Missouri Man, in which the Missouri Man came out because New York could not exercise specific personal jurisdiction due to their long arm statute, if you recall. Okay. And so the next case we're going to get into incorporates a little bit of long arm statute and then also incorporates further defining sufficient minimum context. And so, the legacy of Shu lives on. So the takeaways before we get into it, the takeaways are going to be here, okay? That we still have a lot of questions of purposeful availment, and the big takeaways from this case, as I have them, are deliberate, substantial connection. And so remember that prior video, my two viewers out there, that I said that substantial connection is not a formal standard. It's kind of like a factor. So I think I'm like 20% right. There was a continuing obligation, and they could reasonably anticipate being hauled into the court of Florida in this instance. And so, enough said, we'll get into the facts. So, the plaintiff is the almighty Burger King. Okay. Hot take, I like Burger King. And sometimes I prefer a Whopper over a Big Mac. Just putting that out there. And the defendant is Rudzewicz, and I'm just going to call him defendant. And this was in 1985 is when it was heard in the Supreme Court, but it bears mentioning that a lot of the things that went down during like the actual dispute were in the late 70s. And you'll see as we talk about the rise and fall of this franchise. Okay, so plaintiff, BK, enough said. You already know that. Rudzewicz, defendant, franchise purchaser in Michigan. Okay, so what happened here was that defendant, he bought a franchise. So if you're unaware, you buy franchises, and then then you can open up their business, give them some profit, follow their rules, and get to use their name and whatnot, and you get to keep some of the profits as well. So they had to follow the franchise rules. Now, the contract that the defendant established was with the headquarters, and headquarters is in Florida. I think it's in Miami, Florida. And so the only real time that defendant did go down to Miami like once or twice or something on like some kind of business trip, so to speak. But other than that, he has no other contacts there. He doesn't have at least contacts that are related to the plaintiff's claim, right? Which is a big point. Okay. So D also, keep in mind, he's not necessarily the owner, but he's an investor of another person. So he is part of this suit, and somebody else is too. Now that I think about it, this might be kind of irrelevant to the facts right now, as I will explain them. But before the formal agreement, there was a lot of disputes. And by the end of the agreement, they came to a conclusion that we can have a 20-year deal in which you will pay us at least $1 million over that course of time, I believe. And the thing is that after the deal was hit, the late 70s was late Carter years, and that was a period of stagflation. And so a recession hit really hard, and they tried to renegotiate, okay, but to no avail. So headquarters sent a whole bunch of default notices because that franchise in Michigan was not, they weren't paying their rent. They just weren't paying anything back. And so eventually BK came back and said, the king has spoken, y'all are closed. But D said, I don't listen to kings, especially the kings of burgers, and we're going to keep operating. So Burger King sued, And D said, what are you going to do? You can't take me into a Florida court because y'all don't have jurisdiction over me. Okay. And on its face, I guess, it's not unreasonable to kind of think that because he doesn't really have a lot of contacts. And I guess the court didn't, I don't know the history of the court up to that point that well, but I would suspect that there wasn't a lot of, definition as to what counts as sufficient minimum context. So, you know, before we get into everything else, if we try to apply our prior understanding of international shoe, right? And so we know that purposeful availment, right? Was it deliberate? I guess in a sense, right? He is, or BK has deliberately, for sure, availed themselves to Michigan, right? But they're not hauling BK over to Michigan. So, right, has D availed himself to Florida? And it's not that clear. The biggest availment that we have is that he has the contract with headquarters. Right, he doesn't necessarily have like a home there. He doesn't work for the headquarters necessarily, right? So it's not as clear. So the holding of the case is that we will apply sufficient minimum context, first of all, and bottom line, that there is power to exercise specific personal jurisdiction from a Florida court over D. Okay. Now, worth noting that trial court actually sided with appellate court actually sided with Rudzewicz. And so, I mean, like, there's also a dissent part in here too, and that we'll get into really briefly because it's a dissent at the end of the day. But the big holding of this is that Rudzewicz made a deliberate substantial connection in the form of their contract. Like this not like a very small deal. Like it's a big deal that he made this really big contract with the headquarters specifically to Florida, right? And so he could reasonably anticipate that if something went down, he would be hailed over there. Okay. Now, if we add a wrinkle to this case, actually, if Rudzewicz made a contract with like a Chicago office, for instance, like a regional office of Burger King in like Chicago, and then Florida headquarters try to sue Rudzewicz to hail him in a Florida court, we actually wouldn't have anything here because he made the contract with Chicago, right? And so he would have purposely availed himself to Chicago, but not Florida. Okay, you see, like that little wrinkle does make a big difference here. Also clarifying that physical presence is not a requirement by the 14th Amendment. And last, this is just like throwing it in because it's a key point to look out for in hypos, is that P's claim of breach of contract in which they're trying to hail Rudzewicz into Florida, right? D's contract is specific to that claim, right? I mean, D's contacts to Florida is the very breach of the contract in which P is claiming, right? And so, big note there. Okay. Now, if we go to the dissent, I'm just gonna kind of read some of my annotations here, but Brendan wrote the majority, and there were two dissents. Stevens wrote that there was not context by Rudzewicz, and so the appellate court was right in that he didn't have like fair notice that Burger King would hail him over, right? Because the standard here is like reasonably anticipate, so it can be implied, right? But because of the nature of like headquarters, like this big conglomerate versus small Rudzewicz over here, right? Like he needed proper notice for that. And yeah, yeah. Like I think um another part is that Rudzewicz, like he didn't anticipate, like it's a big deal for a small person to be hailed into a Florida court. So you need like proper notice about that, because a big business, like if you hail them on surprise, right? It's not that, like it's not as big of a deal to like shore off those costs. Whereas that unfair bargaining power, all of a sudden, D gets hit with a burden of things because, because of contract uncertainty. And so I think they invoke that argument. Huh. Um, yeah, that's pretty much it for that. So next we're gonna go to Asahi, I believe, and we're gonna talk about stream of consciousness. No, yeah, stream. No, sorry, not stream of consciousness. Stream of commerce. And so I will see you then.